Hello, ladies and gentlemen. Welcome to a new topic, and the topic is Chapter 4. And Chapter 4 deals with an incredibly complicated area of law, which is property law. It is rather rigid, an area of law. It is based on all kinds of concepts which you need to know before you can apply it, and yet we are going to look at it from two perspectives: a legal perspective and a business perspective, whereby, of course, the main focus is on business. So that will prevail over a detailed analysis and explanation of what property law is about. Yet, we cannot ignore it because, in general, we first need to explore the legal concepts before we can make the jump towards the business concepts. But okay, that's the challenge of this course. How can we link the two? Now, ladies and gentlemen, what do we find in Chapter 4? We'll explore, of course, property law, and in order to make it a bit understandable for you, though it's extremely complicated, we'll start with an introduction, and in the introduction we'll focus on some of the principles of business law. We'll immediately bring in the business functions of property law, and then in order to make you understand what a system of property law is, we use Dutch property law as an example. In this context of property law, we, and you'll understand later why, also focus on bankruptcy, on a very sophisticated topic, which is buying and selling companies, which we refer to in legal terms as mergers and acquisitions. And as always in the course, we will not forget to explore, superficially of course, the international dimensions of property law by looking into not only civil law, that is what we have been doing by looking into Dutch law, but also looking into common law and Islamic law. Let us start with providing you with a basis to understand what property law is about. That are the principles of property law, which we will find more or less comparably in all legal systems in the world. What we will also do in this introduction is to look at property law from a legal perspective, and of course, as we try to link the two from a business perspective. Let us first do that. Let us look at property law from the perspective of the two disciplines which this course tries to link. Let's start with the legal perspective. What is property law doing for us? It is creating rights, and it defines which rights are available to us, legal subjects. Property rights are very strong rights. The law makes them strong by making them absolute, meaning that they work towards everybody, so in that sense they're very strong. And the rights are exclusive, meaning that anybody who holds a property right can exclude others from making use of it. So the absolute and exclusive character guarantee the strength of property rights. Property law also enables legal subjects to transfer rights, and that transferring of rights is of course key to trading, to making money by exchanging goods, or as we speak about property law, property rights against money. And property law defines what a legal subject's property is, and all that property has a recourse function, meaning that if a legal subject would not meet his obligations, then his property can be seized, can be sold, and the proceeds can be used to settle the debts which he did not meet. So that is the recourse function of all the assets, all the property of a legal subject. Now, if we translate this into what it can mean for business, we get the following list. Property rights have a value, so the law creates the opportunity to have value. Law creates value. By making the rights strong and by having, as you see below, a judicial system which can enforce rights, law protects value. We saw that you can transfer property rights, and this transferring of property rights makes it possible for companies, legal subjects, to realize value. The exchange function, which is made possible by rules in property law. Finally, because the rights are so strong, and that in combination with what you see below, a well-functioning judicial system reduces risk for companies. They can be pretty sure that when they have a right, that the right is protected, and if needed, they can go to court to have their rights enforced. Finally, but that is something of the last years, the last decade I would say, there's more and more interest in human rights and the protection and respect of human rights by companies. Now, we have seen in the past examples where that did not happen. For example, oil spills in African countries destroying farmers' land. Because property is so key to our society and even considered and defined as such as a fundamental right, this means that when a company would violate a legal subject's property right, that is considered extremely negative, and that may, and that is then the last point from this slide, affect the reputation of a company. So in this sense, we can also link respect for human rights, respect for property rights to the business interest of having a positive company reputation. Now, how does it work? In other words, what are the principles of property law? This is actually the very basis of property law, and this basis helps in understanding all what follows about property law. First of all, you see the Latin numerus clausus, meaning that all the property rights are as such stated and defined in the law, and it is not possible by legal subjects to create an additional property right. It is a closed system, a limited number. Property law creates rights, and those rights apply to something specific. They apply to a specific object. That is reflected in the specificity principle. Not all property rights, but some of the property rights are entered, documented into a public register for the reason they are so important and so vital to the economy that it should be clear to people on which property rights rest. That may sound a bit theoretical, but the example is simply houses and land are documented in a public registry. The registry is public, so everybody can access it and can see who owns a specific piece of land or house. Then the nemo dat rule, which is in principle obvious in the sense that if you have a property right, you can transfer it, but only if you have it. You cannot transfer a property right that you do not own. Then, as discussed, the recourse, or if we use the American word, foreclosure function, meaning that all you own, all of a legal subject's property, are available for recourse by creditors. Finally, the prior tempore potior iure principle. On the same object, more than one property right can rest. For the moment it's a bit theoretical, but with an example you may understand it. You can have two mortgages on the same house. The principle of property law is that the oldest property right prevails over the newer property right. So if there are two mortgages, one of them is the oldest, that one prevails over the second one, which means that the second one is more risky, and that explains why second mortgage rights in general have a higher interest than the first older mortgage right. Those are the principles of property law, and I hope they will help in understanding the rest of the module. From the principles just discussed, we can make the step towards the Dutch property law system. But also here we will first start with an overview and then gradually move on into the details of the system. As said, when we discussed the principles, property rights is a limited set of rights. Here that is reflected in the words closed system. And in this closed system you see that you have property rights which can only be on the object being a thing, and property rights which can be on the object being a thing but also being a right. First, let's list them, let's introduce them to you. You see on top ownership. Now, ownership is the fundamental right of property law, which is defined, as you can see in Article 1 of Book 5, as the most comprehensive right the owner, the legal subject which holds the right, can have on a thing. A few notions. First of all, ownership is theoretically only possible on a thing, which means a tangible, and for ownership of intangibles, and you see on the right hand side the intellectual property rights, we use the words entitled to. This most comprehensive character means that basically an owner can do with the object he has the right on what he wants, from which for us the most important is the opportunity to transfer ownership, because that allows legal subjects, including companies, to trade, to do business by making the ownership right available to another legal subject against a payment. Now you see an arrow from comprehensive to the definition of limited property right. And the limited property right is actually a part of the property right which you make available to another legal subject. We call that process encumbering, and you see it in the definition of a limited property right that it is a right, and the limited property rights are listed above in the closed system as servitude, leasehold, superficies, apartment right, usufruct, pledge and mortgage. So they're basically part of the ownership right, included in the ownership right, but as a part of it made available to another legal subject. And from a business perspective, the most important dismembered rights, limited rights, are pledge and mortgage. Now, pledge and mortgage give the holder of the right a very special position. The rights are used in financing to provide security for the loan. So the legal subject which wants to be financed will be requested by, let's say, the bank to give the bank the right of pledge and mortgage. That provides security to the bank because the bank knows that having these rights, it can have its claims settled without having to take into account other creditors of the person it gave the loan to. Now, there's one thing which you should realize now, and the details will follow later. On registered property, you place the right of mortgage, and on all other property, you use the right of pledge. That is, for the moment, a brief overview of the system of Dutch property law. Okay, we did an introduction to Dutch property law, and we're now going to move on and to look into that property law system a bit more in detail by looking at the various types of rights. They were introduced to you in an overview, but now we will look at some of them one by one. First of all, you basically see here the foundation of property law, and that is land and houses. Now this is reflected in this article, which defines what ownership of land comprises. And then we will not look into all the subs of Article 1, but focus specifically for our understanding on the E and F. First of all, you should realize that anything which is built on land or attached to it is owned by the owner of the land. So this beautiful house we see here is owned by the owner of the land. And the beautiful plants and vegetation and trees we see here, they are connected to the ground, and as such the law makes them part of the ownership of the owner of the land. Now this house is a typical property, and that property is called immovable. Dutch law defines what immovable is. You can see it here in the Article 3 of Book 3. Immovable are land and everything which is connected to the land permanently in whatever way. And then the law takes a very simple approach to defining what is movable. Movable is everything which is not immovable. So something is not movable because you can move it. No, it is movable because it is not immovable. Why is this distinction relevant? Well, there are a couple of reasons for it. Transfer of registered property, and immovable are registered property, require a notarial deed. Immovables are registered property in the sense that they must be registered in the public register we talked about. And finally, it also has a tax dimension in the sense that immovable property, immovable things I should say, are subject to a transfer tax, which as of the 1st January of 2021 will have three types: one for starters, 0%, one for people buying a house for living in it of 2%, and an 8% transfer tax for investors, so people who buy real estate in order to resell it at a higher price. Now we introduced registered property, property which is registered in the kadaster, which is the Dutch name for the public register. But that is not only applying to immovables, some movables also must be registered, and that makes them registered property. And we saw in the very beginning that if you want to finance registered property, the security right you can give to a bank is mortgage. So on a house and land, and as we see here, an airplane, you can place and encumber it with the right of mortgage. And we have another type of registered property that are ships. Ships are not immovable, so they are movable, but because they are registered property, the security right of mortgage is available to encumber them with, so financing of a ship is also done with the security right mortgage. And then the last example of registered property, and that's a bit complicated, is that a dismembered rights, and you see the dismembered rights on the bottom, must also be registered in the public register, so that makes them also registered property. So what you see on top is the bit of a difficult sentence. A dismembered right on registered property is also registered property. So if you encumber a house with a mortgage, the mortgage must be registered, so the mortgage is registered property. Now, that is the overview of dismembered rights. Let's try to move on to the next slide. And the next slide introduces another legal element of property law, and that is the concept of components. Now, what is a component, or what is component? You can see it defined in Article 4 of Book 3. A component of a thing, so a tangible, is anything commonly considered to form part of that thing. A wheel of a bike is commonly considered to form part of that total thing, which is called a bike. So what is now the relevance of anything being a component? It means that if you transfer ownership of a thing, you also transfer ownership of all its components. They need not be separately negotiated or documented. When you sell the whole, you sell the parts, and if the parts are components, they transfer with the transfer of ownership. A second option for being a component is that something tangible, a thing, is attached to a principal thing in such a way that it cannot be separated, taken from it, without substantial damage either to itself, to the thing, or to the component of a thing. So that's why you see here the picture of a kitchen. You can simply say a kitchen is part of a house, so in that sense it's a component, but you can also say a kitchen is attached to the house, and if you would have to remove the kitchen, you would probably damage the kitchen or the house. So the kitchen is, whatever way you look at it, a component, meaning that if you sell your house, you sell your kitchen, because the component is part of the big thing, and because the kitchen is part of an immovable, a house, the kitchen is as such also immovable. Now here we have a picture of an office building, and you can see that the tables and the chairs are not attached to it, and you can ask yourself, are these desks and computers and chairs a normal part of an office building? I would not by definition say yes. So let's also for the lecture conclude they are not components, and if they are not components, they are not immovable, so they are movable, so you could place the right of pledge on them. Now here we have a warehouse of a company. The warehouse is full of stock. Is the stock a component of the company? No, I would not say so. They can be removed rather easily without damaging anything, and the stock is not a regular part of a factory. So it is not a component, so it is not immovable, it is movable. Again, this means that the right of pledge could be placed on the inventory. So if you want to be financed by a bank, the bank can request you to give them the right of pledge on the inventory. And that's just a little note, it's in chapter 7. The company is an independent legal subject when the company has a certain legal form. So if we would ask ourselves the question, who owns the stock? The answer is the company owns it, because a company which is a limited liability company can as such own things, have rights, is treated in the same way with respect to property law as a regular human being, and that is stated in the article which you see here, this Article 5 of Book 2. Now we arrive at a very essential topic from a business perspective, and that topic is, how does the law regulate transfer of ownership? You can imagine that in business, sales of goods contracts are vital in the sense that they make it possible for a company to produce something and to exchange it against money with another legal subject. That process is regulated, and we refer to that in legal terms as transfer of ownership. Now we look into Dutch law, how this is regulated. First of all, we have an article, Article 83 of Book 3, which defines what is transferable. In other words, with what can you do business? Now, the law explicitly states that you can transfer ownership, you can transfer dismembered rights as discussed, pledge, mortgage, etc. And you can transfer debt claims. So that comes down to, for example, an invoice. Those are all transferable, so they're able to be used in business for trade. Then the third paragraph of this article says all other property rights are only transferable where the law indicates so. For the moment we leave that, but that is the article which makes it possible to transfer intellectual property rights, because the intellectual property rights stipulate by themselves what the requirements are for transfer and that they can be transferred. First, we go to general requirements for a transfer, and then we will see that they, in the articles below it, differ for movable and immovable property. The first paragraph of Article 84 of Book 3 contains 3 requirements. First of all, the legal subject that transfers must be able to do so. That is called here the power of disposition, or we can also say to have the right of disposal. You cannot transfer ownership unless you are owner. There must be a legal basis, a valid legal basis, which you can read as a valid contract. Contracts will be dealt with under Chapter 6, so we leave that for the moment as well. And what we will now focus at is the third requirement, the formal delivery. And you see in the 2 articles below that that is differently for immovables and movables. When we talk about immovable property, land and houses, the Article 89 of Book 3 says that there should be a notarial deed of transfer. So you have to go to the notary to draw up that deed, that authentic notarial deed, and that must be followed by the registration in the public register. Now, that in itself is clear, that's a formal process. The rules on formal delivery of movable property are a bit more extensive. First of all, the basis is that you hand over the thing of which you transfer ownership to the acquirer, to the buyer. But that is described in the law as transferring the possession of the thing by enabling him, the buyer, to exercise the same actual control over the thing as the alienator could. Well, that is simply said, handing over. But it is not always practical to hand over the thing, the good you sell. Think, for example, of a bike, which is somewhere, and then it could be unpractical if you have to go there, pick up the bike, and give it to the buyer. So the law facilitates this giving possession by giving alternative options for the delivery. The handing over is the basis, but we will see in the next slide, and then specifically in the article 115, that there are some other options. First of all, 114 of Book 3 makes a so-called symbolic delivery possible. If the bike is somewhere else, you could give the key to the buyer and say, look, the bike is there, here you have the key, go and take it. That symbolic delivery also qualifies as a delivery under the 3 requirements as stated in Article 84. But then, even more important is Article 115, because that gives the option to transfer possession, in other words, to deliver, by means of a two-sided declaration. And the article provides 3 opportunities. And the 3 opportunities I'll show you on the next slide. For the moment, the essence is to understand that by agreeing, by a two-sided declaration, you can constitute the delivery and as such meet the delivery requirement of the law of Article 84. And then if the other 2 requirements are also met, valid title, right of disposal, the ownership transfers. Now to the next slide for the overview of delivery methods. First of all, on top, we are using the bike again as an example. You see that the seller hands over the movable, the bike, to the buyer. That's the delivery requirement being met. The second one we also discussed. The keys are given to the buyer. That is a symbolic delivery, and that also meets the delivery requirement of the law. The 3 in Article 115 are indicated here with their original Latin names: constitutum possessorium, brevi manu, and longa manu. The first situation, the seller is the owner, but he agrees with the buyer that he will hold the thing until the moment the buyer wants to have it. The buyer can, for example, go on holiday and say to the seller, okay, I buy your bike, but can you keep it for another fortnight until my return? Under that CP delivery, and that is what you see below the big bike, the situation is that the owner loses ownership because by the bilateral declaration it is transferred, but he keeps on holding the bike, so he becomes from owner a holder for the new owner. In the brevi manu situation, you should think of a situation in which the buyer already has the thing in his possession. He, for example, borrowed the bike from the buyer, or he leased a bike from a lease company, and then by simply agreeing with the original owner, the lease company, or the owner of the bike, that he keeps the bike, then that two-sided declaration constitutes the delivery, which is referred to here under its Latin name, brevi manu. So under brevi manu, the original holder changes into owner. Then the last situation is also very relevant for business. You may have a buyer and a seller, and the goods may be somewhere else in a warehouse. If buyer and seller agree on it and notify the owner of the warehouse, which is referred to here as a third party, then that third party, which was holding the goods for the seller, by the notification to him or her, becomes holder for the buyer. So the goods are still where they are, but the ownership has changed, and the holder is a holder for the new buyer, for the new owner. So these are the 5 options available under Dutch law to meet the delivery requirement for the transfer of ownership of movables. We looked into transfer, specifically of movables and immovables, but the law provides more transfer opportunities, which may come in helpful in business settings, but all of these come with their specific, like with movables and immovables, specific requirements. In the overview, we start with immovables and other registered property, of which we now know that that requires for the delivery a notarial deed and subsequent registration in the cadastre. For the movable transfer, ownership transfer of movables, we discussed 5 opportunities, and now some other opportunities. Claims are also transferable, but you must realize, see it at the bottom, that claims are not absolute rights, but they are personal rights. You can only exercise them against the person you have a claim on, so they are not absolute. Claims are not property rights because they are not in the closed set of available property rights, but in terms of assets, they are property, and that is reflected in the fact that they are patrimonial rights, so-called rights with a value. Now you have 3 types of claims, and each comes with specific transfer requirements. The most basic opportunity in business is that you transfer a claim which you have embodied in a paper, which is an invoice. That invoice is towards a certain person which has to pay you. That types of claims, which we call claims by name, can be transferred by a deed. It must be in writing, and you either inform or not inform the person on which you have the claim on the transfer. When you have a claim to bearer, you simply have a piece of paper, like in a supermarket when you deposit empty bottles, and anybody who comes to the supermarket with that paper will get that deduction from his bill. So a claim to bearer is simply a paper which embodies the claim and which you can transfer by simply handing over. Then you have claims to order. You can think in terms of a check on which there is a name on the front of the check. You can transfer that claim by handing over the document and by putting a new name at the back, and that putting of a new name on the back is called endorsement. The law provides a solution for other types of claims by simply saying those, if you want to transfer them, should be transferred in writing by a deed. You can also transfer a contract by private or notarial deed, but that requires the cooperation of the other party with which you have the contract. You can also transfer a debt or take over a debt if you take it over. That is possible, but that requires the approval of the creditor after he or she is notified on the transfer of the debt. And then we have the category of intellectual property rights, which we will deal with in chapter 5. You can transfer a patent by a deed, and in order to make sure it works towards the outside world, you have to register that. And trademarks and design rights can be transferred in writing. And for the design right and for the trademark, it also requires for external effect that you register the transfer. Copyright, very simple, a deed, need not be a notarial deed, a simple deed suffices, something in writing, to transfer copyrights. We looked at ownership, and in that context we also mentioned the dismembered rights, a right which represent a part of the right of ownership. Now we'll do two of them specifically a bit more in detail in the following slides to illustrate to you what their relevance is specifically for business. We take the following situation. A company builds an office or wants to build an office on land which it has rented from the municipality. We know that the basic rule in Dutch law is that the owner of the land owns everything built on the land. So building that office on that land would result in the municipality owning the office. You can imagine that that is not the most ideal situation for the company. So the company would like to have ownership of its building. Is that possible? Yes, it is. And we have for these types of situations two specific dismembered rights, the right of leasehold and the right of superficies. With the right of leasehold, you have the right to use the immovable thing of somebody else, in this case the land, in a way you want. However, if you build an office on that land, which you are allowed when you have the right of leasehold, it does not mean that you own what you build on that land. If you want to have that realized, you should also have the right of superficies, because that allows you to build something on the land of somebody else, and because you have the right of superficies, break through the principle of landowner owns what is on the land, and because you break through it with this right, you can be owner of something you have built on the land of somebody else. So what are the two options? What are the options for the company? The company can request the municipality to give them two dismembered rights against an annual payment, the right of leasehold, the right to use the ground, for which you pay a ground rent, which in Dutch is called kanon, and on top of that, the right of superficies, which allows the company to become owner of what it built on the ground of somebody else, in this case, the municipality. So there's two dismembered rights available to solve this problem: long leasehold or leasehold, and the right of superficies. We're talking about dismembered rights, and dismembered rights, the two security rights, pledge and mortgage, have a relevance in the context of external financing. If this company wants to build on the land of the municipality and it requires or would like to have a loan from a bank, then the bank will demand to be given the right of mortgage on the building. The right of mortgage cannot be given on the land because the land is not owned by the company, it is owned by the municipality. But as the company owns the building, it can give the bank the right of mortgage on the building. At the same time, the bank may decide to reduce its risk even more by also insisting on being given the right of pledge. The right of pledge applies to all unregistered property. So the only registered property we have here is the building. Other present and future unregistered property, and you see the example of invoices and inventory, can be seized by the bank and sold in case the company, the finance company, would not repay its loan. So a bank can use two dismembered rights, two security rights, to reduce the risk of non-repayment for a loan. And both of them, just like what we saw, superficies and leasehold, are dismembered rights. So I hope this explains to you, illustrates to you how dismembered rights can play a role in business. A company may end up in a situation that it is unable to pay its debts. That is what we refer to as a state of insolvency. That may lead to a legal consequence, and that legal consequence is a very severe one. It is a declaration of bankruptcy of the company. Now, bankruptcy is viewed differently in the legal traditions. The prevailing view in, for example, the Netherlands, the UK and Islamic countries is that bankruptcy law should protect creditors in the sense that an insolvent company should be liquidated, its property sold and the proceeds used to settle the debts of the creditors. We'll find a different view in common law countries like the USA, where bankruptcy laws actually protect a company in financial problems, and the aim of bankruptcy law is to create a system in which a continuation, a restart of the company free from debts is possible. One could argue that in the end that could be in the interest of the economy. Now, in Europe, in the European Union, we are moving towards that business turnaround principle. In 2019, the EU adopted a so-called restructuring and second chance directive. The aim of that being to request the member states to change their bankruptcy laws in such a way that this business turnaround possibility becomes a possibility for companies in financial problems. In the Netherlands, that has resulted in the Wet Homologatie Onderhands Akkoord, which in English is translated as Financial Restructuring Act. Now, some of the principles of the Dutch Bankruptcy Act are reflected in this selection of articles. First of all, bankruptcy follows a request by one or more creditors or by the debtor himself. Because it can be done by one, the request, it also means that one creditor can use it as a pressure tool. We know that property, from a legal perspective, has a recourse function, and that recourse function is reflected in Article 20 of the Bankruptcy Act. All property of the bankrupt is available for recourse. Now, a little sidestep towards what we discussed, transfer of property. And we know that payment is not an element, a requirement for the transfer of property. So if goods are delivered to another company and the payment is not yet made, the fact that it is delivered means that the ownership goes to the company, the buyer. If that buyer goes bankrupt, they are part of the bankrupt property, and those goods, even if they are not paid, can be sold in order to generate proceeds to settle the debts of the creditors. Now, creditors are considered all equal. They will receive, in principle, a proportion of the proceeds, a proportion that is equal to the proportion of the total claims that their debts represent. But the law also creates priority rights like taxes, employees' wages, salaries, and those have a priority over the creditors which do not have a priority. That's why they are called unsecured creditors. And we should realize, going back to pledge and mortgage, that those dismembered rights are not affected by a bankruptcy. So pledge and mortgage rights holders can exercise their rights irrespective of the fact whether there is a bankruptcy or not. Finally, also a bit going back to what we discussed, we said that one of the three requirements to transfer ownership is the right of disposal, but the bankrupt does not have that right of disposal anymore, so that simply means that he or she or the company cannot transfer ownership anymore. This slide presents you in a nutshell the bankruptcy process, or better said, the steps in a bankruptcy process. We know that a creditor can request a court to declare a bankruptcy. Now in the Netherlands, we now have this Restructuring Act, which makes it possible for the debtor to propose a reorganization scheme, and if that financial arrangement is accepted, he is freed from debts, he is not declared bankrupt, and he can continue the business. If not, the bankruptcy is declared and registered in the Central Insolvency Register. The court will appoint a curator, receiver, administrator, there are various words for it, and appoint a supervisory judge who oversees the whole bankruptcy process. The bankruptcy is published in the Staatscourant and reported to the Chamber of Commerce. We know that the debtor loses the right of disposal, so he cannot trade anymore. The receiver has the opportunity to terminate employment contracts without having to pay any transition compensation or any other financial compensation. If the company would have no assets at all, the receiver can terminate the process, and the bankruptcy is terminated due to the fact that there are no assets to be distributed, to put it better, to distribute the proceeds to the debtors, to the creditors. If there are sufficient assets, claims are submitted, and the claims are discussed at a so-called verification meeting where all the creditors are present. The debtor may offer a final arrangement, a so-called composition. If that is accepted, the creditors are paid, usually just a part of their claims. If not, liquidation will have to be implemented, and after the liquidation, the proceeds are distributed among the preferred creditors, and if anything is left, to the unsecured creditors who are last in the line. There are some interesting links between law and financing, and some of these links will be presented to you on the next slide. We have discussed the possibility to transfer a claim, specifically a claim by name, which is, as best example, the invoice. Factoring is a method by which you use the law to transfer your claims, your invoices, to a bank at, of course, a discount. You will never get the full amount of the invoice, but what it does offer you is the opportunity to change claims into cash, and in that way very quickly to improve your liquidity. The result is that former company debtors now become bank debtors and can free themselves from their obligations towards you by paying to the bank. Of course, you can take out a loan with a bank, and we know that that involves usually security rights, pledge and mortgage, but you can also put the right of pledge on your invoices. So you give the bank the right to demand payment to them for the invoices you send out in case you do not repay your loan to the bank. Now, if your business partners, for example suppliers, would be knowledgeable about the fact that you have imposed the right of pledge on your invoices, they might become suspicious. Now, in order to avoid that the use of the right of pledge works out negatively towards the business, the law offers the opportunity of an undisclosed pledge, which means that you do not have to disclose that you pledged your invoices to your business partners. So that allows you to continue your business. And then a last opportunity is that a bank can bundle mortgage rights, a whole set of claims, and can transfer that whole set, sell that whole set to another bank, or sell it to a newly incorporated special purpose vehicle, and that vehicle then issues shares to generate the money to pay for the bundle of mortgage rights, and that allows a bank to change claims it has into cash, which it can use for other business ventures. Companies can merge with other companies or can decide to purchase another company. Within law, that area is referred to as mergers and acquisitions. We're going to look at the three methods, of which the first one is a so-called asset transfer. Here we have a Dutch BV-A and a Dutch BV-B, and what happens is that the Dutch BV-B acquires all the assets of BV-A and pays for that sum of money to BV-A. Now that may sound simple, but in practice that is fairly complicated due to the fact that we have seen that there are all types of assets, each with their own transfer requirements. So doing this is not impossible, but it requires that all the statutory transfer requirements are met in order to make sure that indeed the assets of BV-A are legally validly transferred to BV-B. There is a more simple way, and that more simple way is selling the shares of the company. That is what George Clooney and his friends have done. They have sold their tequila company for $1 billion. They get a 700 million immediate payment and a $300 million if the company meets its sales targets. Now, how have they created their only created company? They have done so by a so-called share transfer. They did not have a BV, but they had a Mexican or American company, and that company had shares, and those shares were transferred to another BV, in this picture BVB. So all the shares of BVA are now in BVB, which means that BVB fully controls and owns, as a result of having all the shares, BVA, and the shareholders are paid for transferring their shares. The third opportunity is a so-called statutory merger. This is the only merger type explicitly regulated in the law. ABN AMRO made use of this opportunity. In a statutory merger, one company completely disappears into one surviving company. So the old shareholders get shares in the new company, or what can happen is that a new entity is created in which the two existing companies disappear, and the shareholders of both disappearing companies then get shares in the new entity. A few words about two other options to acquire a company: the management buy-in and the management buy-out. In the management buyout, an existing management team decides to buy themselves the company they were employed by, and to run the company as being their own. In a management buy-in, we have an outside manager or an outside management team, and they decide to take over the company and to run the company from that moment onwards as theirs. Generally, this will be done via a so-called share purchase agreement, the so-called share transfer, which we have seen in the 3 previously discussed methods. Let's discuss a few international dimensions of property law. First of all, we have extensively discussed the Dutch transfer of ownership requirements, and we can compare them here with ownership transfer in other jurisdictions. Dutch law is the so-called traditio system, and that traditio refers to the fact that delivery is required for ownership transfer. At the same time, Dutch law is a causal system, meaning that if the cause of the transfer, the contract, is not valid, the whole transfer of ownership is invalid. That is the same under English law, but English law is a consensual system, meaning that ownership is transferred at the moment the parties agree on the moment it should be transferred, and if the parties make no agreement on it, the system is that at the moment the contract is entered into, that the ownership transfers. Now, Islamic law is also consensual, but is an abstract system, just like Scottish law, meaning that the invalidity of the underlying contract will not by definition result in the invalidity of the transfer of ownership. Now, we have discussed the security rights, pledge and mortgage under Dutch law, and you will find in common law comparable rights, but on the details they may differ. Lien is what we call the retention right. If you repair something for somebody and he does not pay, you can keep the property until he pays. So the right of retention is comparable to the English lien. Pledge is in its definition under common law comparable to pledge as we know it under Dutch law, but we have a specific term under common law which is called charge, and charge is comparable with what we discuss as undisclosed pledge. The asset remains with the debtor. And then the mortgage right. Under Dutch law, we saw that when you give a bank a right of mortgage on your house, you remain owner. That is not the case in the common law mortgage tradition. In order to get the mortgage, you must transfer ownership to the bank, and once you have met all your financial obligations, the ownership returns. Then Islamic finance is different from, let's call it, Western finance or conventional finance. The underlying principles differ in the sense that under Islamic finance, the parties involved are supposed to share risks. Under Islamic finance, you are not allowed, under Islam I should say, it's not only applicable to finance, but you are not allowed to pay or charge interest. That is the so-called riba prohibition. And in principle, you are not allowed to charge interest or to punish if the fees are paid too late. That is in line with the idea of risk sharing. Now, this risk sharing is of course not present in Western conventional finance. Interest can be charged and penalties can be agreed upon in the case of late payments. So that is something to take into account when you do international business, that your counterpart or your Islamic bank may uphold completely different principles than the ones you are used to when you grow up in a jurisdiction where the conventional rules of finance are followed. So please take that into account. Now we have reached the end of this chapter 4 lecture on property law, and we're going to finalize with the next slide. And the next slide tries to integrate law and accounting concept. It is an attempt to look at a balance sheet and try to assign the comparable legal concepts to the concept mentioned on a balance sheet. That fits in with the whole purpose of this course, that is to link law and business. But I'm going to ask you to have a look at it for yourself and to see whether you recognize the concepts we just discussed today, and to become aware of the fact that accounting and legal concepts do not identically overlap.